Hey, what's up, everybody? It's attorney Aaron Watson with the Watson firm. Big, 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 big verdict announced today. Two big verdicts. It ain't a good day for social media, man. Not a good day for YouTube. Not a good day for Facebook. I mean, $375 million. Oh my God. Listen, there's a lot of whiskey being consumed tonight by the lawyers who defended these social media companies. I mean, just a devastation to the nation. $375 million verdict. And then also that verdict was over in New Mexico. Another verdict was rendered, what was it, yesterday, March 25th, in Los Angeles for $6 million. Looks like the jury deliberated 40 hours across 9 days. And the jury consisted of 7 women, 5 men, and found both Meta and YouTube responsible for negligent design and operation of their platforms. Negligence was a substantial factor in causing the harm to the plaintiff, that they knew that the design was dangerous for minors. Key word here, minors. The more I looked into these cases remind me a lot of the tobacco cases. Do you remember when they were making a big deal in the tobacco litigation about Joe Camel? How Joe Camel, they were using those advertisements and cartoons to persuade kids and children to use cigarettes, tobacco. And here, notice that the jury found that these two companies, Meta and YouTube, in the LA verdict, the Los Angeles verdict, knew that the design of their product was dangerous for minors. I go and look at these cases. Check this out. When we talk about injuries to kids, these are what we call sympathetic plaintiffs, meaning that, listen, social media companies, it's going to be tough to go in there and fight against kids, against children, children who've been harmed, children that are complaining of addiction and depression, body dysmorphia, anxiety, eating disorders, self harm, all caused by your product. It's gonna be that, a tough, tough litigation going forward. Check this out, guys. There are over 10,000 personal injury cases from families alleging that their children were harmed by social media addiction. 10,000 cases, man. It's one thing for an adult to go into the courtroom and say, listen, man, I was scrolling social media so much I got depressed, this or that. Jury may not be sympathetic towards an adult, but kids, uh, 10,000. And listen, the more these verdicts hit the news, because I suspect that this isn't going to be the only these multi-million dollar verdict against these tech companies. It's just going to be tough to go in there against kids, but not just that, school districts. There are 800 school districts suing to recover costs from increased counseling expenses, mental health services, reduced academic performance that they attribute to social media addiction. So I'm a personal injury lawyer. I handle products liability cases. I handle cases against, sometimes against school boards and school facilities. Those are some of the toughest cases. Why? When the school board is involved, it's another sympathetic party, Nobody's, the jury's not going to hear the school board come in and say, listen, the kids are failing. The kids are having to get more counseling. We're having to spend more money, and say, school board, get out of here. Just pay for it. Here's the other deal. You got a school board on one side and a big tech company with hundreds of billions of dollars on the other side. Who's the jury gonna find for? I mean, you got an unsympathetic defendant with big pockets. And the thing is, everybody knows they have deep pockets. So usually, when I'm in a lawsuit, if I sue someone in their individual capacity, let's just say I sue Joe Blow, the jury doesn't know how much money Joe Blow has. The only reason I've probably sued him is because he has an insurance policy that's paying the claim. But under the rules of evidence, I can't tell the jury that there's a big multi-million dollar, billion dollar insurance company that's backing Joe Blow. The word insurance cannot be mentioned in a trial, at least here in Florida, in a personal injury trial. And so the jury assumes that Joe Blow is going to have to pay this verdict out of his pocket. And so the jury is less inclined to hit Joe Blow with a big verdict if they think that, hey, he can't pay the money. I can't pay $10 million. But here, the jury ain't going to have any problem awarding 10 million, 20 million, 100 million, $300 million. And so let me explain something to you guys. So we have 10,000 personal injury cases, essentially kids and their parents alleging that their kids were injured by these social media companies and YouTube and Facebook, Meta, school district, over 800 school districts, all saying that, hey, we've been injured by these big tech titans. Not just that, the state attorneys, state attorney generals, more than 40 state attorney generals have filed lawsuits primarily against Meta, alleging consumer protection violations, deceptive practices, and failures to protect minors, kids. Oh, man. This ain't going to be good, man. Meta, YouTube. Listen, I know y'all got billions of dollars, man, but somebody needs to just go sit down in the conference room, in the mediation room, to see if these cases can be resolved, because it ain't looking good. I keep seeing the word kids, minors, self-harm, that these platforms are, at least the plaintiffs are alleging, that causing these kids injuries and the school district injuries, and the state attorneys general are saying you guys are causing the state's injuries. It just reminds me of the tobacco litigation, where tobacco for a long period of time said, hey, we're not addictive. Hey, we're safe. All the while, they got studies in their cabinet showing the opposite, that it was addictive, that tobacco is not safe and healthy. And then what the plaintiffs' lawyers would do is highlight kids, that their strategy is to addict kids young, and then they grow up to be adult addicted people. And so they have a customer who continues to pay money throughout their entire life. And it looks like the plaintiffs in this case are doing the same thing. So there's now mind you, so because we have thousands, literally thousands of plaintiffs involved, and it's only going to get bigger. These are called mass torts, and so the trials that are happening right now, they're called bellwether trials. And essentially what that means is that, there's a judge who has all of these cases in front of them. There's actually two judges, but let's just say, for example, the federal multi-district litigation over in Oakland. There's a judge who essentially presides over all of these claims, rather than have all these claims, 10,000 claims tried all over the country, they try to consolidate them. And so the bellwether trial just means that they're selecting a few to go to trial, just so that both sides can kind of assess the strengths and the weaknesses of the case. Now, if Meta and YouTube and these defendants had won these cases, let's just say those plaintiffs had gone into court, tried these cases, and the jury said, hey, we don't buy it, we're going to give zero. Now the plaintiff's lawyers are going to be thinking, oh, maybe we don't have that strong of a case. Maybe we need to be reducing the amount that we're asking for to try to get these cases resolved. Now, if you get a verdict of $327 million, now the defense lawyers are thinking to themselves, maybe we need to get these cases resolved, because now the plaintiff's lawyers and the plaintiffs are going to be wanting more money. Now that they see what jurors are paying for these cases, $6 million is a lot of money. $10 million is a lot of money, but $300 million? Oh, listen, I saw this verdict and I thought to myself, I need to start putting up some the advertisements for social media cases. And I'm not the only one. I'm sure thousands of lawyers across the nation are going to be thinking to themselves, okay, so my point is that this isn't going away anytime soon. You got an unsympathetic defendant with what is perceived to be unlimited resources, kids being injured, and verdicts that are, you know, unheard of, verdicts that are very high. It only is going to snowball from here. So they do these test cases, one in New Mexico, got another one over in Los Angeles, and it didn't go well for these tech companies. I mean, it didn't go well. Now, will they appeal? Heck yeah, they're going to appeal it. I don't know if a $300 million verdict will stand muster, but it might. And here's what they're arguing, what the plaintiffs' lawyers are arguing in these cases. There is so for a long time, lawyers and plaintiffs have been able to bring claims for what's called product liability. And all that means is that you put out a dangerous product that causes harm, and it should have never been put out, but you did. And so we're going to bring a lawsuit for damages. I bring those cases all the time. We see these cases, say, for example, with pharmaceutical drugs. You put out a drug, you should have known it was dangerous, should have known that it had A, B, and C consequences. You didn't warn us. You didn't do what you needed to do to make this as safe as reasonably possible. So we're going to sue you. I've had cases involving lawnmowers where the blade flies off, oyster steamers where the thing explodes, UTVs where the vehicle, when you turn too far to the left, the whole thing tips over. Those are called products liability cases. But here's what's interesting about this case with the tech companies is the lawyers are suing under product liability. But how these tech companies and social media companies have been able to avoid liability in the past is there is a statute. It's called the Section 230 of the Communications Decency Act, passed in 1996, that they've been relying upon. And what it does is, in a nutshell, is it says, hey, social media companies, they can't be sued for statements that other users make. So, say for example, all they do is provide the platform. You can't sue me for just hosting the platform. If somebody goes on there and they try, let's just say there's a predator on there and they're making these statements that's harmful, there's protection for it. In fact, in plain English, it says if someone posts something defamatory on Facebook, you can go after the person who posted it. Good luck with that. But you can't go after Facebook. You see what I'm saying? So it's just like they provide the venue. But what goes on inside of that venue, you got to go after the people who are actually causing the harm, not necessarily Facebook. And so that's how they would get out of these lawsuits and say, hey, we're relying on the Communication Decency Act. Section 230, which says that, hey, you can't sue me for what somebody else did on our platform inside of our venue. We're just providing the place for the party. You got to sue the person who was actually in the party causing the harm. But here's where the lawyers got smart. They said, no, we're not suing you for what some other user did. We're suing you for the product that you created. And the product is the venue, the dance hall where the party is being held, and how you designed the venue, how you designed the dance hall, how you designed the website. And so what are the plaintiff lawyers arguing here? They're saying that this is a product liability case. We're not suing you for what the conduct of your users. We're suing you for your conduct in engineering this space, engineering this product that we call YouTube or that we call Facebook. So, what are they arguing? They're saying that social media platforms are products. Products. They're not neutral pipelines for speech. They're not just the venue where the party takes place. No, these are engineered, well thought out products. Uh, they're also saying that the design of the product is defective. So, say for example, if you suspect that your platform, let's just say Facebook, is addictive, should you allow for indefinite scrolling to where you can just scroll forever? Just you wake up in the morning, just scroll. Now, what if there were testing showing that that actually can contribute to a person's addiction? It's never ending. You can never get to the bottom of it. You go to most websites, you're going to scroll and get to the bottom, but they have indefinite scrolling. Who came up with that? Why is it indefinite scrolling? Autoplay. You scroll on your iPhone, videos start playing by themselves. You don't even have to click on them. Back in the day, you have to touch it on your phone. They start scrolling they start playing by themselves. If you're addicted to it, that's just something just to keep you looking at it, keep you on Facebook, keep you scrolling. And know that the plaintiffs' lawyers are arguing that this is by design. But it is by design. This didn't just happen randomly. Somebody somewhere said, you know what? Let's make these videos play on their own. Let's have it to where it's infinite scrolling. The disappearing stories that you see on platforms like Facebook. Why do they disappear? If you know that the story's going to disappear, that kind of causes you to say, oh, let me go watch it before it goes away. Let me go and take a look at it before it goes away. What's the purpose of that? And now some folks say, oh man, just because it disappears, that's not going to make you go on to try to go check it out before it disappears. May not. Maybe so. The jury in over at New Mexico said, hey, I don't know, and so the plaintiffs' lawyers are arguing that the design is defective, the beauty filters, the disappearing stories, the push notifications where somebody does something on Facebook and all of a sudden, ding, you got it on your phone. You can't even do your homework. These kids can't even do their homework. Ding. Videos start playing on their own. And so, and I also saw some statements where I think there was some internal documents where folks were comparing social media to the casino. We all know that, you can walk into a casino, it's bright lights, the slot machines making all this music and noise, and, folks become addicted to it. They get a rush out of going there, win or lose, they get something out of it. But that's all the casino is designed. They don't put all those lights and bells and whistles there for no reason. There's a lot of thought that goes into how casinos look, how they smell, how they present themselves to the world. And the same thing applies with social media. This is by design, is what these lawyers are arguing. And so they're saying that the design is defective, the buttons, the algorithmic feeds, the push notifications, the autoplay, the infinite scrolling. And then they're also saying, listen, you don't have to guess whether or not this is addictive. These companies knew it was addictive. They knew it. And so the lawyers then show the jury internal research. Like Meta had this internal research document called Project MIST, MYST. It was a study that showed that the executives within that company were aware that their platforms, this is what the plaintiffs are arguing, that their platforms harmed children's mental health. Didn't the tobacco companies have the same thing? Internal documents where the lawyers were able to show, listen, this wasn't a mistake. Joe Camel isn't a mistake. These candy cigarettes that you see, they aren't a mistake. the infinite scrolling, it's not a mistake. When you walk into a casino, the way everything looks and lights up is not a mistake. This is by design, and there's a lot of money going into the design of these places. So they say that they knew of the dangers and they failed to warn of them. Listen, if I invite you over to my house and I know that my back porch is made out of wood and it's rotten, I know it, that it could cause harm to you. I got to warn you of it. If I let you go out there and I know that it's rotten, or I should have known that it's rotten, you likely have me on the hook if you go on that back porch and the back porch collapses on you. The same thing with this social media. If you know that it's harmful, if you know that it's addictive, you got to tell me about it. You got to warn me about it. But then the question is when your aim is children, if the aim is, as the plaintiff lawyers are arguing, to get them addicted young, do they even have the capacity to understand a warning? But they're arguing that Meta and YouTube, that they know, and they had knowledge of the risks associated with harm to children. And so it's not these lawsuits aren't about the content that individual users post, because like I said, the argument is you can go after those individual users for that. It's about the design of the product, that these aren't mistakes that have contributed to addiction. So here in the first case was KGM versus YouTube. It was tried over in Los Angeles, California. And here's what happened. A 20-year-old California woman identified by her initials KGM, referred by her lawyers as Kaylee. She began using YouTube at age 6 and Instagram at age 9, posting 284 YouTube videos before finishing 284 YouTube videos before finishing elementary school. Jesus. I don't even think I've posted 284. Well, maybe I posted on Facebook or something, but this is an elementary school student posted 284 YouTube videos before finishing elementary school. She alleges spending up to 16 hours in a single day on Instagram. She claims the platform's addictive design contributed to body dysmorphia, anxiety, depression, self-harm, ideation, and experiences with bullying and sextortion. I got to look up what sextortion is. But she's claiming she was harmed and that she's addicted, and she's been addicted since she was a child, since the age of 6. And now she's 20 years old and she's still addicted and suffering from the harm caused by these tech titans. The plaintiff's lawyer, Mark Lanier, I think Mark Lanier is a preacher, by the way, but very reputable lawyer nationally. He started off his opening statement with this. This case is easy as ABC, addicting the brains of children. You got to say that's a powerful line. The jury's never going to forget it. This case is about ABCs. Everybody knows ABCs. Those jurors are never going to forget that statement. Addicting the brains of children. He compared Instagram and YouTube to digital casinos and said the companies had engineered addiction in children's brains. He referred to Project Mist, which was the internal Meta study of 1,000 teens, showing that Meta knew vulnerable children were particularly susceptible to addiction, and that parental controls made little impact. Internal Meta employee communications. One employee wrote, Instagram is like a drug, and they are basically pushers. They're referencing all these different. Mark Zuckerberg gave a deposition February 18, 2026. But and just so you know what a deposition is, before you ever go to trial, the lawyers are going to go and subpoena everybody who has knowledge about the incident. And they're going to find out what they have to say so that when they get to trial, there's no surprises. So that's what a deposition is. And so if you sue a company like YouTube, a company like Meta, you're going to talk to Mark Zuckerberg. And that's what's cool about being a lawyer. So for my young, aspiring lawyers out there, one of the things for me that was the coolest is that when you become a licensed lawyer and you file litigation, you have subpoena power. And so you can issue a subpoena with the court signing off on it to Mark Zuckerberg, and he has to come talk to you. Issue a subpoena to the owner of, you could issue a subpoena to the president of the United States, issue a subpoena to the chief of your police department, and he's going to have to come, or she's going to have to come and sit down and talk to you. I remember when the first time I did that, I was like, wow, as an officer of the court, I have this decorated person. When I had a lawsuit against Yamaha before, and we were taking the depositions of all these different folks. I remember this one guy had to have an interpreter because I think he came from Japan or somewhere, but somewhere overseas, but they had to come and talk to little old me. And so it's a really cool profession in the sense that, you can go up against corporate giants, Meta, YouTube, Yamaha, all Motorola, pharmaceutical companies, and fight for justice for your clients. And folks hire you because they say to themselves, "I'm David trying to fight Goliath. Something wrong, something bad happened to me. I know that something bad happened to me, and I need a fighter to go up and fight for me." And so, kudos to the lawyers who said to themselves that, you know what, we're going to take up the fight, because God knows you have to have a lot of money for that fight, and you have to have a lot of passion. I'm sure these lawyers litigated for years before the trial. Spent a bunch of money. I can imagine suing Facebook. You're probably spending millions of dollars. And then you talk about 10,000 personal injury cases, states getting involved, school districts getting involved. And so that was what the KGM versus Meta and YouTube and Los Angeles, what that case was about. And so that case resulted in I believe it was a $6 million verdict, if I'm not mistaken. Now, what did the defense argue? The defense apparently was represented by an attorney, Paul Schmidt. He argued that KGM, Kaylee, was the person who was doing the suing, that she struggled with a lot of these issues, emotional abuse, family issues, bullying, way before, she had a troubled childhood. They're saying that social media didn't have anything to do with it. And they had her therapist, challenged her therapist and said, hey, you know what? A lot of this stuff that she's complaining of, she already had. And this wasn't because of Meta. And then YouTube had attorney Lewis Lee, who argued YouTube is a responsibly built streaming platform, not a social media site. He went into detail as to say that Kaylee, her 5-year average on YouTube, the watch time was only 29 minutes, essentially saying that YouTube wasn't a problem. They're pointing the finger at Meta. Attorney Lee said, he told the jurors, infinite scroll is not infinite. It's as little as a minute and 14 seconds. It's not social media addiction when it's not social media, and it's not an addiction. I assume what he's arguing there is that, hey, YouTube isn't social media, and the addiction was primarily with Meta and not YouTube. But the verdict in that case, if I'm not mistaken, was $6 million. So the jury awarded $3 million. And then it also ordered, they found another $3 million, if I'm not mistaken, for punitive damages. And punitive damages are just money damages that you award to punish someone. And how the jury broke down their damages award, the first $3 million was broke down this way. They found that Meta was 70% responsible. So Meta had the verdict was $2.1 million against them, and then YouTube was 30% responsible, and it was a $900,000 verdict against YouTube. Those are what are in what's called compensatory damages. All that is, hey, this is for what you've been through. It could be medical expenses, it could be pain and suffering damages, and so the other $3 million would have been likely for punitive damages. And this is doesn't take into consideration, your how much you pay for medical expenses. It solely is to punish. And so, it looks like the jury kind of sided with YouTube's lawyer and said, hey, she wasn't as addicted to YouTube as she was Facebook or to Meta. And so the jury, they gave 70% fault to Meta and then 30% fault to YouTube. And then right after that, we had the New Mexico verdict, which was the next. Actually, the New Mexico verdict was March 24, 2026, and then the LA verdict, March 25th, 2026. But let's take a look at that. So the New Mexico verdict was 375 million in civil penalties against Meta for thousands of violations of the Unfair Practices Act. And there's a statutory maximum of $5,000 per violation. And I believe the argument here is that they violated that act thousands of times, a lot of times, which kind of added up to that large figure. There is a suggestion that, the $6 million verdict, the $375 million verdict is pocket change for these companies. Meta generated over $201 billion in revenue in 2025. $201 billion. There's an argument there that they're not worried about a $300 million verdict, but let me tell you something. As someone who's made, money here and there, $300 million is $300 million. I don't care how much money you make. That's a lot of money. Nobody, if Facebook said to themselves, hey, that's pocket change, we're going to pay it, they would just pay it, but they're not. They're going to appeal it. And, when you have large verdicts like that, a lot of times when the verdicts get too large, the appellate court will strike them down. And so, we'll see what the appellate court does with it. I suspect that both of these companies and both of these verdicts will have to deal with appeals. And the case will drag out for 2-3 more years, and an appellate court could say, hey, you got to go back and try it again. There was a mistrial. That means there was a mistake at trial. Somebody said something that they weren't supposed to say. Somebody did something they weren't supposed to do. A judge didn't rule correctly on an issue, and so they have to go try the case again. And so, it's good to see that the jurors, really in a novel case, a case that's new. 20-30 years ago, they weren't talking about Meta addiction and YouTube addiction and social media addiction. So this is a new area, a new set of cases that jurors are saying that, hey, you know what? There was an addictive design. The companies knew of the addictive design. They targeted youth. There's tens of thousands of cases out there. You got scientists internally and studies internally that are pretty much suggesting that there was knowledge of all this and that they failed to warn of the dangers. Where do we see this at? We see it all the time, like I said, in pharmaceutical cases, but these social media cases remind me a lot of what tobacco cases, Remember, they targeted the youth. They knew that it was dangerous. They knew it was addictive. They didn't do anything about it. They failed to warn. And all of a sudden, you started seeing warnings on the tobacco packages and all that. So what I suspect is you're probably going to log on to Facebook and there's going to be a huge warning there. But before you even log in, age authentication and all this stuff, but that's not necessarily a bad thing. But it is interesting to me that the majority of these plaintiffs, if not all of them, are kids. And like I said, when you're dealing with a sympathetic plaintiff, you got a tough hill ahead of you. Going in there saying that little Kaylee is depressed and has had suicidal ideations and body dysmorphia, depression and anxiety. She's uploaded almost 300 videos before she was on YouTube, before she graduated out of elementary school, 19 hours a day on social media for you to say, oh, this is all just because she had a rough childhood. No, 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 no. You see what happened with that defense. And so anyhow, guys, that's my take on these verdicts. You know, it's tough day for Facebook, tough day for YouTube, $375 million verdict. Another $6 million verdict as well. And the issue is social media addiction, you know, that causes harm to children. And so as more cases come out, as more verdicts come out, I'll jump on, give you guys my take on them. You know, to the parents out there that are watching, you know, these defense lawyers would tell you, there has to be some responsibility on the parents' part, you know, to help to if the science does show that it's addicting, you know, to uh, usher the kids away from it. You know, it's kind of like I remember being on vacation and we were walking. Where were we just at? Somewhere in the Caribbean, and we came across a casino, and the kids could have walked in, but as parents, we said, nope, you can't go in there. There was cigarette smoke in there, alcohol in there, all these flashing lights and all this stuff. And the kids, they were excited to go and look at it. They were excited to go and to go in there. But we, as parents, said we're not going in there. You know, we don't even want you to sit at one of these slot machines because number one, it's addictive. Number two, we don't want you around this environment. And so, you know, if the lawyers are saying that social media, YouTube and Meta is like a casino, I think that the parents as well have to step up and make sure that our kids aren't spending either much time in the casino or not spending any time in the casino. If you know that your child is on social media for 16 hours, so these are the types of arguments that the defense lawyers are going to make, and you know, it's really up to that jury to decide, you know, what, if any, harm was caused by the defendants, these tech titans, social media. For more information, be sure to like and subscribe to our page. Again, I'm attorney Aaron Watson. I'm the owner of the Watson Law Firm. If you have questions about a potential personal injury case, a civil lawsuit, you know, I should say, if you've been harmed by social media, you know, give us a call because, you know, but I'll end with this. Visit watsonfirm.com or wedemandjustice.com. Look forward to hearing about your potential case and look forward to seeing you all on the next video. Talk soon.